Welcome to the Superior Court Traffic Department. Traffic court is a court of law just like any other court. You are expected to be always respectful of the court and each other. I will now explain how this trial session will be conducted, so please listen carefully. You are here for a trial to contest your traffic or infraction citation. Some people may have misconceptions about how judges and courts operate. Some people may think that a judge expects to believe one side and not the other, or that one side is being truthful and the other is not. Although possible, that is not necessarily what happens in a trial. People that witness an event may see it differently than other people. People may see it from a different angle or any number of different conditions. People will testify differently than other people about the very same event, yet each would be convinced that what he or she saw was the truth about what took place. A judge is trained to follow the rules of evidence that have been established by law. A judge looks for factors of reliability, such as the ability of the person testifying to see or observe the events testified to, or the degree to which a witness was concentrating on the event, as opposed to doing something else. Hearsay is a written or oral statement someone said who is not in court. Hearsay is also documents written at another time. Hearsay is not admissible evidence at trial. Some documents, however, such as calibration records, DMV printouts, or other official records may be admissible. Corroboration is helpful to support the testimony of one side. For example, photos or a witness saying the same thing. A witness's behavior or manner while testifying is important as well. A judge makes decisions based on reasonable and reliable evidence presented in court. If you've been charged with speeding where the officer used radar or LiDAR to measure your speed, there may be testimony about a speed survey. If you wish to challenge the validity of the speed survey, you must inform the judge during your case. When your case is called, come forward to the front of the courtroom, to the left podium in the center of the room. The police officer and any other witnesses for the people will go to the podium to your right, and the defendant and defense witnesses will go to the podium to your left. Bring all witnesses and evidence with you when you come forward to the podium. All witnesses will be sworn under penalty of perjury to tell the truth. The people have the burden of proof, which means that the officer must testify first. Do not interrupt the officer while he or she is testifying. The trial is being electronically recorded, and the recording device cannot make a good record if two people are speaking at once. The judge will let you know when it's your opportunity to ask questions of the officer if you choose to do so. The officer will present evidence to try to prove each element of the case beyond a reasonable doubt, including the identity of the person who committed the offense. The judge may ask the officer questions to clarify any issue. If the officer presents any photos or documents, the clerk will mark them as exhibits numbered 1, 2, 3, etc. Once they are marked, the officer will show them to you. Do not discuss the exhibits with the officer, just look at them. Then the officer will show them to the judge. After the officer testifies, you have the right to ask the officer questions, which is called cross-examination. You are not required to ask the officer questions, but you may if you want. then you have the right to present evidence on your own behalf by testifying, having your own witness testify, and presenting any photos or documents. If you want to present any photos or documents, the clerk will mark them as exhibits numbered A, B, C, etc. Once they are marked, you must first show the officer your photos or documents. Do not talk about them yet, and then show them to the judge. The officer is not allowed to ask you cross-examination questions. However, the judge may ask you questions to clarify any issue. You also have the right to remain silent, which means you do not have to testify or present any evidence. If you have testified and after you have presented all evidence, the officer has the right to present rebuttal evidence. Once the officer has finished presenting any rebuttal evidence, the court will decide the case. If you are found not guilty, the case will be dismissed. If you are found guilty, you will be sentenced. The sentence imposed after a guilty finding by the court will be based on the testimony and the evidence at trial. Sentencing is not based on any bail amount that may have been noted on your courtesy notice or court slip. If the evidence proves excessive speed or dangerous driving, a suspension of your driver's license may be ordered by the court. After trial, you have a right not to be sentenced for up to 6 hours, but no later than 5 days. Because it may be inconvenient for you to return to court for sentencing later, the court will presume that you prefer to be sentenced immediately. After trial, you have the right to appeal the court's decision. Please wait for paperwork from the clerk before leaving court. Please turn off all cell phones and video recording devices. Please do not talk while the court is in session, except when presenting your case. Trials will start momentarily. Thank you.